in 2017, Law Commission of India has submitted a report on what kind of reforms are to be brought in administrative tribunals. So report number 272 was the report which deals with the reforms which are to be brought in administrative tribunals, and this report was given by Law Commission of India. On the basis of the recommendations made by the Law Commission of India, the reforms were taken up in 2021 through Administrative Reforms Act 2020. And what are the advantages of administrative tribunals over regular courts? For example, if it is a matter of taxation, or if it is a matter related to your transfer, suspension, it's a more technical issue. So the regular judges may not have the technical expertise to deal with such cases. That's one thing. So with the growing complexities in administration, with the growing specialization, the ordinary courts with ordinary judges are not better equipped to deal with the specialist cases. So tribunals, they contain not only judges, they also contain technical experts. So compared to the courts, tribunals have got better technical expertise in handling cases. That's one advantage. Second advantage is, if you go to a court of law, it is very expensive. Justice in a court of law is expensive because you need to pay court fee, you need to engage a lawyer. But in a tribunal, you don't need to engage any lawyer. You can argue for yourself. And there is a legislation in this country called Indian Evidence Act. So there are certain procedures which are to be followed if it is a regular court of law. But if it is a tribunal, you don't need to follow the lengthy procedures. So these are the advantages. No, it is only for civils. If it is an administrative tribunal, we have central administrative tribunal and also state administrative tribunals. So the employees serving the state government, they come under state administrative tribunals. And we have all India service officers, like Indian Administrative Service, Indian Police Service, Indian Forest Service, and also Central Civil Services. They all come under CAT. Central Administrative Tribunal, it deals with the grievances of the civil servants of the Union Government, civil servants of the All India Services. A tribunal at the state level, State Administrative Tribunal, it deals with the grievances of the civil servants of the state government. Ordinary people have nothing to do with these tribunals, especially administrative tribunals. So the administrative tribunals were set up in 1976 because they have certain advantages over the regular courts. The first one is the procedures are simple. It is a less expensive and the justice is delivered with a greater speed. So these are the advantages of the tribunals over the regular courts. That's why these tribunals were set up. Initially, there was a debate. There were two important cases which went before the Supreme Court with respect to tribunals. One is Sampath Kumar case. The second case is Chandra Kumar case. Chandra Kumar case. One is in 1987. Sampath Kumar case is in 1987. Chandra Kumar case is in 1997. The question before the Supreme Court is, if there is a state administrative tribunal, is it equivalent to the High Court in terms of powers, or is it subordinate to the High Court? Because if it is subordinate to the High Court, a decision given by the tribunal can be challenged before the High Court. From there, it can go to the Supreme Court. The chain increases, the length of the chain increases. In Sampath Kumar case, the Supreme Court said tribunals have equivalent power like the High Courts. So they are not below the High Court, they have the same powers like the High Court, which means a case decided by that state administrative tribunal can directly go before the Supreme Court. But later on, in Chandra Kumar case, the Supreme Court said both High Court and Supreme Court are constitutional courts. They form part of the higher judiciary. Both have got judicial review. So tribunals cannot have equal powers on par with High Court. They come under the jurisdiction of the High Court. Now it becomes lengthy. First, you have to challenge in the state administrative tribunal. A decision given by the state administrative tribunal can go before the High Court. From there, it can go to the Supreme Court. Now it will take more time. So that's why Law Commission of India said the judgment given in the Sampath Kumar case is more apt. Let the tribunals decide the case. Let the matter go directly before the Supreme Court. If this is done, there will be no delay, long delay. So keeping these judgments apart, what are the reforms which were brought in 2021? So in India, we have a wide variety of tribunals, administrative tribunals, tribunals for other purposes. So Law Commission of India has said, in terms of appointment, in terms of service conditions, in terms of removal. Though all the tribunals perform similar kind of functions, there is a lot of difference, there is a lot of variation in appointing them, in providing service conditions, in the removal of these members of the tribunals. That's why Law Commission of India in 2017, in its 272nd report, it said that let there be rationalization, let there be uniformity in the way the members of the tribunals are appointed, in terms of service conditions, in terms of removal as well, at what time they retire, how many years of service. In all these things, there is a lot of divergence, lot of diversity, creating a lot of confusion. And these reforms were taken up in the tribunal reforms of 2021. So you should go through that 2021 Act, what reforms were brought in. This is how you need to answer the question. When they started, 1976. What is the amendment? What are the related Supreme Court cases? And what are the problems with the existing tribunals? And how that is being attempted to reform through 2021 Act. That's about the second question. Question number 3. Compare and contrast the President's power to pardon in India and in USA. So in GS paper 2, there is a topic called comparison of Indian constitution with other countries. So this is a question which comes under comparative constitutions. Under this year, 2 questions have come under comparative constitution. This is one question. The question is about comparing the pardoning power of Indian president with American president. That's first part of the question. And there is a second part in the question. What are preemptive pardons? This is a phenomenon which is there in United States of America. We don't have this concept in India. So what is preemptive pardon? In India, if a person gets convicted, which means if a person is given punishment, later on the matter goes to the governor or the president for clemency, for mercy. You all know about mercy petition. But even before punishment is given, the matter cannot be taken to the president or the governor. So preemptive pardon means if a person is facing charges of crime, even before the person is given punishment by the courts, the matter can be taken to the American president for pardon. That is called a preemptive pardon. So this concept is there in United States of America, but it is absent in India. In India, a person who is given punishment by court of law can only go before the president and governor for pardon. Even before the punishment is given, he cannot go to the president or the governor for pardon. That is the concept of preemptive pardon. The concept of preemptive pardon says, even before a person is convicted, even before a person is given punishment, he can apply for pardon to the president and the governor. That is the case in United States of America, but not in India. And if you take the first part of the question, you also know ordinance making power. When the parliament is not in session, when the state legislature is not in session, the president can issue ordinance, governor can issue ordinance. What is ordinance? Ordinance is nothing but a law made by the executive branch. Is it a discretionary power? Can the president and the governor do on his own without the advice of the Council of Ministers? No, it is not a discretionary power. The pardoning power is also like that. The power to issue ordinance is done by the president on the advice of the Union Council of Ministers set by Prime Minister. Similarly, the power of pardon, it's not a discretionary power. The president can exercise it only on the advice of the Council of Ministers set by Prime Minister. The governor can do it only on the advice of the Council of Ministers headed by Chief Minister. But in America, it is a discretionary power because America doesn't have parliamentary democracy. America doesn't have the concept of Council of Ministers. That's one thing. Then, in India, the pardoning power, if it is exercised by the president and the governor, can it be subjected to judicial review? If pardon is given by the president or governor with an ulterior motive. So can the courts question this? In India, if the president has given pardon to a person who doesn't deserve it for political reasons, can that be questioned by courts? In India, it can be done. So there was one important case, Epuru Sudhakar versus government of Andhra Pradesh. So in this case, the Supreme Court said, we can question when if the power is exercised with a malified intention, with a bad intention. If it is exercised with a bona fide intention, fine. So there is a limited judicial review even in India. Not every action of the president or governor with respect to pardoning power cannot be questioned, even by the courts in India. But if the president exercises that power with a malified intentions, with a bad intention, that can be subjected to judicial review. But this is not the case in USA. In United States of America, the pardon given by the American president cannot be questioned in any court of law. This is the main difference. So in United States of America, the pardoning power of the American president is not subjected to judicial review. But in India, the pardoning power of the president can be subjected to limited judicial review. That's one difference. See, the president will have the pardoning power with respect to offenses mentioned in the union list. The governor will have the pardoning power with respect to offenses in the state list. But even with respect to offenses in the state list, if the punishment is a death penalty, the governor cannot pardon. But only the president can pardon. So the president of India can pardon a death sentence even under a state law. But this is not the case in USA. In the United States of America, the American president cannot pardon death penalty under a state law. Second difference. Third difference. Court-martial, judgments given by military courts. Even in that case, pardon can be given by Indian president. The American president cannot do that. So these are the differences with respect to pardoning power between Indian and American president. That's the answer. Then discuss the nature of Jammu and Kashmir Legislative Assembly after the Jammu and Kashmir Reorganization Act 2019. Briefly describe the powers and functions of the Assembly of the Union Territory of Jammu and Kashmir. Do you know why this question has come? It is there in the news. See, while nominating some of the MLAs to the Legislative Assembly of Jammu and Kashmir, there was an amendment which was done to the 2019 law which says nomination can be done even without the advice of the Council of Ministers headed by Chief Minister. For example, if you take Rajya Sabha, there are 12 nominated members in the field of literature, art. So the nomination of the members of Rajya Sabha can be done by the President on the advice of the Council of Ministers headed by Prime Minister. But here in the case of Jammu and Kashmir, the nominated MLAs can be nominated without the aid and advice of the Council of Ministers headed by Chief Minister in Jammu and Kashmir. So this change was brought in 2019 and that has been in the news. Few days back it has come in the newspaper. That's why a question has come. And remember, so before 2019, Jammu and Kashmir was a full-fledged state. In the last 75 years, for the first time, a state was converted into union territory. But in the past, many union territories were elevated to the status of state. Goa was earlier a union territory. Later it was made a state. This happened with many union territories. But Jammu and Kashmir is an exception. For the first time in post-independent India, a state was converted into a union territory. So if it is a union territory, the union government will have very wide powers. So here, when it comes to powers of the Legislative Assembly of Jammu and Kashmir, you know that in the 7th schedule, under Article 246, there are 3 lists: union list, state list, and concurrent list. So Jammu and Kashmir Legislative Assembly can make laws with respect to all the subjects in the state list, but with a few exceptions. Public order, police, land. These are the 3 items in the state list where the Legislative Assembly of Jammu and Kashmir doesn't have power. Legislative Assembly of Jammu and Kashmir can make laws with respect to subjects in the state list with the exception of public order, police, and land, which means in these 3 areas, the center is powerful. It can make laws with respect to subjects in the concurrent list. So we have Delhi as well. Delhi, Puducherry, Jammu and Kashmir. In all the union territories, we have a person called a Lieutenant Governor. So the Lieutenant Governor enjoys wider discretionary powers. And the matter even went to the Supreme Court. The Lieutenant Governor of Delhi versus Arvind Kejriwal. The matter went to the Supreme Court. There the Supreme Court said representative democracy is a basic feature. The Lieutenant Governor cannot bypass the decisions of the Council of Ministers very frequently. The Supreme Court said unless there is a valid reason, you cannot deviate from the decisions of the Council of Ministers. So here the point is, if you compare the legislative assemblies in the states with the legislative assembly in the union territories, the powers of the legislative assemblies in the union territories, they are limited. That's the point. That is what you need to highlight. Question number 6 on Attorney General. This is a static question. Not a difficult question, it's an easy question. The Attorney General of India plays a crucial role in guiding the legal framework of the Union government and ensuring sound governance through legal counsel. Discuss his responsibilities, rights, and limitations in this regard. To refer to Article 76. Article 76 speaks about Attorney General of India. He is the chief legal advisor to the Union government. He is assisted by Solicitor General, Additional Solicitor General. So he represents the Union government in the Supreme Court and High Court. He has the right to audience in all the courts. He can even participate in the meetings of the parliament, in the parliamentary committees, but without the right to vote. So these are his responsibilities include defending the government of India in the Supreme Court, in the High Courts, in all the cases where the Union government is involved. And he gives advice to the Union government on all the legal matters which are referred to him. Then rights, as I said, he can participate in the sessions of the parliament, in the meetings of the parliamentary committees, he can speak, he can participate, but he doesn't have the right to vote. Then when it comes to limitations, unlike the Chief Election Commissioner, unlike the Judge of Supreme Court and High Court, he doesn't have security of tenure, which means he can be removed at any point of time by the President. So he stays in office during the pleasure of the President. So doctrine of pleasure, which means he can be removed at any point of time. He doesn't enjoy the security of tenure. So that is what you need to write for this question. Question number 6. This is not related to politics, but it is related to social justice or government. Women's social capital complements in advancing empowerment and gender equity. Explain what is social capital. The interconnectedness among the people. That's what we say social capital. You know, there is a report of second ARC. Second Administrative Reforms Commission has given 15 reports. The 9th report, it deals with the social capital. So social capital, it includes cooperative societies, it includes non-governmental organizations, it includes civil society organizations. We are all connected by different channels. So that interconnectedness which exists among the human, that is called social capital. So here, you do know Muhammad Yunus. Way back, he started something called a microcredit. The poor women, they are made to form into a group, which we say self-help group. This is a concept called group lending. If I give you loan individually for a person, the chances of not repaying the loan are very high. You will not repay it. But if the money is lent to a group of poor women, even if 1 or 2 members are not interested in repaying the loan, the others will put pressure. So the concept of group lending was quite successful in increasing the repayment of loans. And SHG, self-help group, the poor, especially in the rural areas, the poor women, they form into groups. They save some money. On the basis of the savings done by that group, banks give credit to them. They use this money for their self-employment activities. So that will empower the women economically. This concept is called SHG. In the 2 Telugu states, we have Dwakra, development of women and children in the rural areas. So the 2 Telugu states, Andhra Pradesh and Telangana, they are pioneer states in this SHG movement. We have the highest number of groups with highest number of credit delivery and credit disbursement. So the concept of self-help group, which involves group lending, it's a powerful tool to address poverty in the rural areas and to economically empower the women in the rural areas. So that is what you need to write for this question. Women's social capital, which means the poor women coming together, forming into a group, making savings and then getting credit on the basis of this saving. This is all called social capital. Women's social capital complements, it helps in advancing empowerment and gender equity. If a woman is financially independent, she can take decisions with greater courage, bold. The respect of the woman within the family will increase. Her voice carries weight. They can start spending money on what is important for her children, what is important for herself. This is all about nothing but empowerment. So it promotes gender equality within the family. That is question number 7. Is it group lending? If it is a group lending, you can use it. You can give that example. So take question number 8. Civil society organizations are often perceived as being anti-state actors, then non-state actors. Do you agree? What is your stand on this? So we say NGOs, non-governmental organizations, civil society organizations. Are they anti-state? Are they against government? Are they against government? Or is it that they are there to help the poor people by bridging with the government? So the definition for NGO or civil society organizations is they act as a bridge between the citizen and the government. They try to connect the citizen with the state. But there are also instances where the actions of the NGOs or civil society organizations, it affected the interests of the government. If you remember, in Tamil Nadu, there was an attempt to build a nuclear power plant at Kudankulam. Some of the non-governmental organizations, by receiving funding from the foreign governments, they were leading the protests against the nuclear power plants. Establishing a nuclear power plant, generating nuclear power, it serves India's interests. But some of the NGOs, they started organizing protests against nuclear power plants. So this is seen as anti-state. But there are some NGOs who are doing that, but not all NGOs. Most of the NGOs, they play a very important role by bridging the gap between the citizen and the state. For example, there are some states in this country which are affected with the Naxalism, like Chhattisgarh, Jharkhand. So government machinery presence in the remote areas is very limited. But the schemes are reaching the people there in these areas. How? It's through NGOs. So non-governmental organizations or civil society organizations, they play an important role in improving the service delivery in the remote areas, in the difficult terrain areas, in the areas affected by left-wing extremism, Naxalism. The government will choose certain NGOs, will give money to them, and they take it to the people. Service delivery improves. It's not only that. Civil society organizations, they expose corruption in the government. They make the governments accountable to the people. They create awareness among the marginalized people. They raise the voice of the marginalized people. They generate awareness about the rights of the marginalized people. For example, in Odisha, there was one company called Vedanta. They tried to mine bauxite in the Niyamgiri Hills. So these people were supported by NGOs in fighting for their cause. But Niyamgiri Hills is very sacred for them. Niyamgiri Hills is very sacred for them. They don't want mining in these areas without their consent. So non-governmental organizations or the civil society organizations, sometimes they are seen as anti-state. You can give the example of Kudankulam nuclear power protest. But otherwise, they serve a useful purpose by acting as a bridge between the people and the government. And they also implement several schemes and they improve the delivery mechanisms. They increase accountability on the part of the government as well by exposing corruption, by making the people informed. They also create awareness among the most marginalized and backward groups. So we cannot see NGOs merely as anti-state. They are non-state actors trying to bridge the government with the people. Of course, there are instances where some of the NGOs, they started playing against the state as well. But that is not the only dimension. So that's the answer. Question number 9, it is related to international relations. So I am skipping this question. Question number 10. With the waning of globalization, post-Cold War world is becoming a site of sovereign nationalism. Elucidate. See, there are several advantages of globalization. It's because of globalization, India was able to have impressive economic growth for the last more than 3 decades. According to the National Multidimensional Poverty Index released by Niti Aayog, we were able to bring more than 40 crore people out of poverty. It's because of liberalization, privatization, and globalization. But in the last 1 decade or so, increasingly, the governments, they are not interested in globalization. They were trying to protect their domestic industry by raising tariffs. So till recently, we had a big issue with the United States of America, Donald Trump imposing tariffs on Indian exports. So increasingly, several countries across the globe, instead of promoting globalization, they are promoting deglobalization. They are trying to protect their native industry by imposing tariff. So that's the question. So with the waning of globalization means the momentum of globalization is coming down. People are not interested in globalization. If there are certain advantages with globalization, the cost of goods will come down, the cost of services will come down. But increasingly, to protect the interests of the respective countries, they are not interested in globalization. They are trying to protect their native industry and they are going in the opposite direction of globalization. So the increasingly countries have become sovereign. So here, the interests of the nation are paramount. So in the process, they are even going to the extent of undermining the forces of globalization. So that's what we say, rise of right-wing governments. BJP is a right-wing political party. So even in the United States of America, in Europe, there are several countries where right-wing political parties have come to power, and there is increasingly focus on the interests of the nation. That is called nationalism. So the rise of sovereign nationalism, looking at the interests of the government, looking at the interests of the particular country. That is the question. This question number 11, constitutional morality. This question has already come in the past, in the GS paper 2 itself. What is constitutional morality? What is constitutional morality? To put it very simple, it refers to what the Constitution believes in. For example, take the preamble. What is the preamble speaks about? Liberty, equality, fraternity, unity and integrity of India, protecting the dignity of the individual. These are the goals of the Indian Constitution. This is what is constitutional morality. Constitutional morality refers to what the Constitution believes in. Constitution believes in equality. Where is equality for women? So when it comes to inheritance of property, even today, if it is Islam, daughters get only one half of what the son gets. Even today in India, there is prevailing gender inequalities, caste inequalities. That is not constitutional morality. Constitutional morality is what the Constitution believes in, what the Constitution aims at. It's not only liberty, equality, and fraternity. The Constitution also believes in rule of law. It believes in supremacy of the Constitution. It believes in separation of powers. It believes in checks and balances. All that comes under constitutional morality. So constitutional morality, to put it very simple, it means what the Constitution of India believes in. Constitution of India believes in federalism. It believes in secularism. It believes in republicanism. It believes in rule of law. It believes in parliamentary democracy. It believes in federal constitution. It believes in theory of separation of powers. It believes in theory of checks and balances. It believes in rule of law. It believes in supremacy of the Constitution. It believes in liberty, equality, fraternity, and dignity. It believes in independent judiciary. They all come under constitutional morality. That you need to explain. Then, of course, judicial review. Without judicial review, how do you protect the supremacy of the Constitution? So in India, the Constitution is supreme, and the protection of supremacy of the Constitution is put in the hands of the judiciary. That's why the Supreme Court is the final protector and interpreter of the Indian Constitution. So the power to interpret is nothing but the power of judicial review. Constitutional morality is the fulcrum which acts as an essential check upon the high functionaries and citizens alike. You have seen very recently, the Supreme Court has given a judgment on Tamil Nadu governor. It has put certain timelines. The governor must decide within 3 months. In certain cases, he should decide within 1 month. It also put time limits on the President of India. They are high constitutional officers. Is that fair? Is that right? That is very much right. The President, when he takes oath of office, this man says, I will bear true faith and allegiance to the Constitution of India. I will be loyal to the Constitution of India. I will uphold and protect the Constitution and the laws. This is the oath which he takes, President. This is the oath which the governor takes. But what are you doing? A bill passed by the state legislature without giving valid reasons, you are not giving assent, you are keeping it pending. Doesn't that mean undermining the Constitution? You are undermining your own oath. That's the point here. Constitutional morality says that Constitution is supreme. Then governor has a duty to protect the supremacy of the Constitution. President has a duty, but they are failing in their duties. That's why the Supreme Court has intervened and said that, my dear President and Governor, you cannot keep the bills pending without a valid reason. You must decide them within a reasonable time frame. There's nothing wrong doing that. Because every institution created under the Constitution of India, they are supposed to uphold the constitutional values. No exceptions. Even if you are the President of India, you take the oath saying that I will bear true faith and allegiance to the Constitution of India. I will uphold the Constitution and laws. That means you should give assent. Or if you don't want to give assent, give the reasons why you are not happy with the bill. So without doing anything of these two kinds, if you keep it pending, you are undermining the authority of the parliament, or you are undermining the authority of the state legislature. That is undermining the Constitution. That is undermining constitutional morality. That's the question. That is the first part of the question. Constitutional morality is the fulcrum which acts as an essential check upon the high functionaries and citizens alike. whether you are parliament, whether you are executive or legislature or judiciary, or even if you are an ordinary citizen, you should conduct yourself as per the provisions of the constitution. No privileges conferred. In view of this observation of the Supreme Court, explain the concept of constitutional morality and its application to ensure balance between judicial independence and judicial accountability. I just told you, independence of judiciary is one of the basic features. It is part of the constitutional morality. And independence of judiciary is very much required, you know. If the judiciary is not independent, it cannot protect the Constitution of India. But take the other part of the statement, accountability, judicial accountability. Accountability is one of the features of democracy. It doesn't matter whether you are executive or legislature or judiciary, you have to be accountable for what you do. Take executive. Executive is accountable because every 5 years there is election. So for whatever omission and commission you do, you are answerable to the voters. If you have performed well, you are re-elected to power. If you have not done well, you are thrown out of power. Executive accountable. What about legislature? Every 5 years there are elections. MLAs and MPs, they have to go before the voters. Again, there is accountability. What about judiciary? Judges are not elected by people. They can't be removed by people. So among the three branches of the government, executive, legislature and judiciary, judiciary is least accountable to the people. And now with the system of collegium, in India, judges are appointed by judges. This doesn't happen in any other democratic country. So if judges are appointed by judges, if they do something wrong, who should correct them? There is no mechanism to correct them. Then you will become an unaccountable institution. That is also a threat to democracy. So judiciary every time says that executive and legislature should be accountable. What about the accountability of the judiciary? So by creating the system of collegium, the accountability on the part of the judiciary has got diluted. And you know, the theory of checks and balances is a basic feature. Each branch must exercise control over the remaining two branches. If there is such a check, all the three branches, there is a balance of power. Now there is a check of judiciary over executive and legislature. The check on the judiciary is not there. It will create imbalance. That will undermine the theory of checks and balances. But theory of checks and balances is a basic feature. So that you can discuss here. This question number 12, it is about amending power of the parliament under Article 368. And you know the story. The Indian Constitution has conferred the amending power on the ordinary legislative institutions. Parliament is a creation of the Constitution. It is a legislative institution. So that is the meaning here. Ordinary legislative institution means parliament and state legislatures. The power to change the Constitution is given to the parliament and the state legislatures. They are nothing but ordinary legislative institutions. With a few procedural hurdles, it is prescribed in the Constitution. An amendment under Article 368, for example, recently there was an amendment bill, 130th Constitutional Amendment Bill. It was there in the news. If you are a Prime Minister, if you are a Chief Minister, if you are a Minister, if you are arrested in any case, if you are in the jail for 30 days, you will lose your office. That's the bill which was introduced. Article 75 and Article 164, they have to be amended. So any bill which is meant for changing the Constitution under Article 368, it has to be passed in the Lok Sabha and Rajya Sabha by a total strength of the House. That is one requirement. In addition to that, 2/3 of the members present and voting. This is the condition laid down. A bill under Article 368 relating to amending the provisions of the Indian Constitution must be passed in the Parliament in Lok Sabha and Rajya Sabha separately by a majority of the total membership of the House and 2/3 of the members present and voting. If it is a bill which is related to federal provisions, like a 7th schedule, making changes in the list, union, state and concurrent list, half of the state legislatures must also agree. These are the procedural details. In view of the statement, examine the procedural and the substantial limitations on the amending power of the Parliament to change the Constitution. If you want to change the Constitution, there are two kinds of limitations: substantial limitations, procedural limitations. What are procedural limitations? I told you that it has to be passed by a majority of the total strength and also 2/3 of the members present and voting. And again, there is something which is said in the Constitution. A constitutional amendment bill under Article 368 has to be passed by Lok Sabha and Rajya Sabha separately. There is no provision for joint sitting. These are procedural details. And then what are substantial limitations? These are evaluated in case 1 and the Bharati case. In case 1 and the Bharati case on 24th April 1973, the Supreme Court said, in the Constitution of India, there are certain provisions. All provisions are not equally important. There are certain provisions which are very, very important, which are very basic, which are very fundamental. They are called as basic features. So Parliament under Article 368 can amend any provision of the Indian Constitution, but not basic features. This is the substantial limitation. This is substantial limitation. I will give an example. NJAC, National Judicial Appointments Commission, to replace the system of collegium, NJAC was brought in 2013 by the 99th Amendment. This was struck down as invalid because the Supreme Court said primacy of the judiciary in the appointment of the judges of the Supreme Court and High Court is a basic feature. The Supreme Court said judiciary must have an upper hand in appointing the judges of the Supreme Court and High Court. That itself is a basic feature. That is violated because of NJAC. So NJAC invalid. This is substantial limitation. This is the answer. Procedural limitations, substantial limitations. Substantial limitation is put by doctrine of basic structure. Doctrine of basic structure is evaluated in case 1 and the Bharati case. What does this doctrine says? Basic features cannot be amended. Non-basic features can be amended. That is the answer for this question. Question number 13. Discuss the evolution of collegium system in India. Critically examine the advantages and disadvantages of the system of appointment of the judges of the Supreme Court of India and compare this with USC. What is collegium? It is a body of judges. If you want to appoint a judge of the Supreme Court, collegium contains 5 judges. The Chief Justice of India and 4 senior most judges of the Supreme Court. If you want to appoint a judge of the High Court, collegium contains only 3 judges. Chief Justice of India and 2 senior most judges of the Supreme Court. In the collegium, there is no representation to High Court. If you want to transfer a judge from one High Court to another High Court, this is again done by collegium. At this time, again it has 5 judges. Let me clarify. While appointing a judge of Supreme Court, while transferring a judge from one High Court to another High Court, collegium contains 5 judges. Chief Justice of India, 4 senior most judges of the Supreme Court. The opinion given by the Chief Justice of India must be supported by at least 3 out of the remaining 4. Majority. And then if it is appointing the judge of the High Court, the opinion of the Chief Justice of India must be supported by 1 out of the remaining 2. And we did not have the system of collegium in India till 1993. From 1950 till 1993 in India, there was no system of collegium. Collegium was created in 1993. And there are 4 important cases relating to appointment of the judges of the Supreme Court and High Court. First judge case, second judge case, third judge case, fourth judge case. First judge case in 1983. Not case 1 and the Bharati case. I will try to get the name of the case. So first judge case in 1983, second judge case in 1993, third judge case in 1998, fourth judge case in 2015. Try to see here from 1950 to 1983. If you want to appoint the judge of the Supreme Court or the High Court, there is a consultation between the executive branch and judicial branch. Executive branch means president, advised by the Council of Ministers. Take Article 124. Article 124 says, a judge of Supreme Court shall be appointed by the President by consulting the Chief Justice of India and such other judges of the Supreme Court and High Court. So President means Council of Ministers, it will be Prime Minister. So while appointing a judge of Supreme Court, a judge of High Court, while transferring a judge from one High Court to another High Court, there is consultation. What do you mean by consultation? Exchange of opinion between executive, judiciary. If both agree, appointment is done. If both disagree, no appointment is done. So from 1950 to 1982, there was equal and balanced role for both executive and judiciary. This balance got disturbed in 1983. In the first judge case, the Supreme Court said, after consultation between executive and judiciary, if there is a disagreement, the executive will have upper hand. The Supreme Court said. Why? Because executive is accountable to the people. There is no such accountability on the part of the judiciary. So the opinion tendered by the executive branch will have upper hand. So that prevailed from 1983 to 1993. While appointing the judges, executive had upper hand. Chief Justice of India is sidelined. And later on, Supreme Court has realized this is a fatal mistake. It will be dangerous for the Constitution of India. So in 1993, they have given an entirely different interpretation. That is called second judge case. In the second judge case, the Supreme Court said, while appointing the judges of the Supreme Court and High Court, there will be consultation between executive and judiciary. If there is disagreement, the opinion of the judiciary will be final and binding. And it is in 1993 in the second judge case, collegium was created. From then onwards, it is being continued. So what are the disadvantages with collegium? Forget about executive and legislature. People from within the judiciary, they are criticizing collegium. So decisions in the collegium are not made transparently and objectively. So there was a lot of bias in elevating judges to the Supreme Court and High Court. If you have family connections, so we had HR Khanna, who decided the habeas corpus case. Sanjeev Khanna became the CJI. D.Y. Chandrachud's son, Y.V. Chandrachud's son, D.Y. Chandrachud became the Chief Justice of India. Familial connections, money, they form the basis for elevation, not the merit and ability. People from within the judiciary are saying, the retired Chief Justices of India, Justice J.S. Verma, Justice Venkatachalaya, they all criticized the system of collegium. The appointments through collegium are not done transparently and objectively. Merit and efficiency are not the criteria. There is a lot of bias. There is no transparency in the working of collegium. Wrong people are being elevated as judges of the Supreme Court and High Court. This is the criticism of collegium, disadvantages. So when decisions are made in the collegium, there is no transparency, there is no objectivity. Say for example, there is a vacancy in the Supreme Court. If 10 people have been considered for the post of Supreme Court, well, who are these 10 people? What are their relative merits and demerits? Why one among these 10 was finally chosen? This will never come into the public domain. And that's why appointments have become diluted. But there are also advantages. What are the advantages? In India, the Constitution is supreme. And who will protect the supremacy of the Constitution? The Supreme Court. For this, the Supreme Court has to be independent. If there is no interference of the executive in appointing the judges of the Supreme Court and High Court, the chances of judiciary remaining independent will be very high. That is the advantage. Right? So the advantages and disadvantages. Then compare this with USA. In India, the judges of the Supreme Court and High Court, they are appointed by the collegium. Collegium contains judges, which means judges appointing judges. But if you take United States of America, they have a better system. In United States of America, the judges of the American Supreme Court, they are appointed by the American president. But this appointment has to be confirmed by the American Senate, which is the upper house in American Parliament. So there is a check and balance. In America, in United States of America, the judges of the American Supreme Court are appointed by the president, executive. But the confirmation has to be given by the American Senate, which is the upper house in American Parliament. So there is a legislative check on the executive powers. This is a better system of appointment.
So how can this can be a better system, executive appointing the judiciary so that they can be ready?
So we can't give upper hand exclusively to the executive. We need a broad-based committee. For example, the proposed NJAC had Prime Minister, Leader of Opposition in the Lok Sabha, Chief Justice of India, then one eminent person, and 2 members from the civil society. So we need a broad-based committee where executive is represented, legislature is represented, civil society is represented. Or we can take the system of America as well. That is also a better system. So here comparing India with USA in terms of appointments. In India, the judges of the Supreme Court and High Court are appointed by judges themselves. Collegium contains judges only. Judges are appointed by judges. And there is no check and balance. That's not good for the country. If wrong people get appointed to the judiciary, there is the guarantee that the judiciary will protect the independence of will protect the supremacy of the Constitution. But if you take America, they have a better system. Judges, that is judiciary, members of judiciary appointed by executive, confirmed by legislature. There's a better check and balance. We can imitate USA. That's the answer for this question, question number 13. Examine the evolving pattern of center-state financial relations in the context of planned development in India. How far have the recent reforms impacted the fiscal federalism in India? What is fiscal federalism? Center-state financial relations. Do you know in the beginning, all the taxes of the union government are not shared with states. For example, personal income tax is shared, corporation tax not shared, excise is shared, customs duty is not shared. But later on in course of time, The 80th Amendment to the Indian Constitution has brought in a new mechanism called alternate scheme of devolution, in which all the taxes of the union government is pooled. In that, a share is given to the states. This is a big improvement. Earlier, all the taxes of the union they are not shared with states. Now, all the taxes of the union government, they are shared with states. Earlier, it was 28%. Now, it is 41%. There was a very big improvement. Initially, all the states had a share of 28% in the central government tax revenues. Now that has phenomenally increased to 41%. So this was a very big improvement in the center-state financial relations. In addition to this, see the second part of the question. How far have the recent reforms impacted the center-state financial relations? What is the recent reform? GST. So the 101 amendment to the Indian Constitution has centralized the taxation powers related to indirect taxes. Now we have GST Council under Article 279A. So the GST Council will decide everything. So the states have lost their financial powers to the GST Council. That is a negative impact. Earlier, in the 7th schedule, we have 3 lists: union list, state list, concurrent list. With respect to all the indirect taxes in the union list, center is supreme, parliament is supreme. With respect to all the indirect taxes in the state list, state legislatures are supreme, state government is supreme. Whenever they need money, more money, they can generate more money by levying indirect taxes. Now what happened? After the implementation of 101 amendment, with respect to indirect taxes, center has given up its power, states have given up their power. To whom? GST Council. In the GST Council, there is center and all the states. Now that has to be decided together. For example, take the union government. GST is an indirect tax reform, which means direct taxes are not affected. Personal income tax, corporation tax, customs duty, they are not part of GST. So the union government, when it needs more money, it can increase more money by levying personal income tax, corporation tax, customs duty, and also cess and surcharge. But if you take the states, they get a lot of money through indirect taxes. They are subsumed in the GST. So now the ability of the state government to generate additional revenues by imposing indirect taxes has greatly come down. So states have made greater sacrifice. The financial autonomy of the states got compromised. That is the impact, negative impact. Then what is the positive impact? After the implementation of GST, the state GST revenues have phenomenally increased. That is the positive impact. And then when it comes to Finance Commission of India, you know that on the recommendations of the Finance Commission of India, the central government tax revenues are shared with states. On the recommendations of the Finance Commission of India, that 41% is given to all states. This 41% has to be distributed among the states, for which the Finance Commission will give a criteria. So this criteria is broadly on the basis of 2 things: equity, efficiency. Efficiency is given less weightage. Equity is given more weightage. If your state has got more population, more area, more poverty, will get more money. But who is responsible for increasing the revenues of the union government? States in southern India, states in western India, they are responsible for increasing the tax revenues of the union government. But who is getting this money, more money? Northern states are getting more money. So southern states had a problem. They said, we are responsible for development in the last 3 decades. You are taking a lot of money from us in the form of personal income tax, corporation tax, and you are spending this money in the poorer states. And even this money is not being properly spent. Take Uttar Pradesh, Bihar. Money is being spent on education and health. This money is not being properly spent. Even today, the proportion of children who are out of school, they are increasing in the northern India. On one hand, you are taking away the money from southern and western states and giving it to northern states. That may be good in one sense, promoting national unity. But even this money is not being properly spent. So that's why southern states are now asking, give more weightage to efficiency. For example, population stabilization was done by southern states. Their ability to generate tax revenue has increased a lot. So they have a lot more tax efficiency. You try to give more money on the efficiency criteria, not on the equity criteria. This was one more issue. So these are the things which you need to discuss under center-state financial relations. So inequality in the ownership pattern of resources is one of the major causes of poverty discussed in the context of paradox of poverty. Have you heard about Oxfam International? Oxfam International very regularly conducts a study about growing inequality. In India, the wealth of top 10 billionaires, is more than the budget of the union government. The budget of the union government, it runs into 50 lakh crores. They have more wealth than the budget of the union government. Top 1% of the population, they command 40% of India's GDP. It all speaks about growing inequality. So one major cause for growing poverty is not having access to ownership. For example, land is one resource. In the initial years of independence, we wanted to implement land reforms, collecting land from the surplus land from the zamindars and giving it to landless people. So land is a resource. Using that resource, you can address poverty. But unfortunately, land reforms in this country are not properly implemented. In addition to this, the poor had a lot of difficulty in accessing credit from the banks. Capital is a resource. Without that, they cannot come out of poverty. Similarly, if you want to get a quality job, you must have quality education. You must be healthy, quality health. You must have a lot of skills. Even for this, money is required. The poor doesn't have. So these are the reasons why there is growing poverty. Inequality in the ownership pattern of resources. It can be financial resources or it can be land resources. As there is inequality in access to resources, that is leading to poverty. That's the question. Question number 17. In contemporary development models, decision making and problem solving responsibilities are not located close to the source of information and execution, defeating the objectives of development. Critically evaluate. This question is all about decentralization. For example, in 1992, we have come up with the 73rd Amendment, 74th Amendment. Things which matter for the people at the local level must be given to local governments. For example, 11th schedule, it deals with the 29 items. 12th schedule, it deals with 18 items. These are the items which are having local importance. But the state governments have not devolved powers to the local governments on these items in the 11th and the 12th schedule. So that's the problem which he is trying to explain. So when the constitution was made by the framers of the Indian constitution, we had that goal of protecting the unity and integrity of India. If you want to protect the unity of India, you want a strong central government. So that's why in the original Indian constitution, a lot of powers are given to central government. So there is concentration of powers. But now we need to move in the direction of greater decentralization. More and more powers must reach from the center to the states. Those powers which are being exercised at the state level must reach to the local governments. Then only the governance will improve. Things which matter at the local level must be decided at the local level. For example, if your teacher is not coming to the government school in the village very regularly, let the Grama Panchayat punish him. Why the chief minister or the minister of education has to deal with that job? If you have control over the local functionaries, the local elected government, things will greatly improve. So that's the question. Then question number 18, the National Commission for Protection of Child Rights has to address the challenges faced by children in the digital era. Examine the existing policies and suggest measures the Commission can initiate to tackle the issue. So NCPCR is a statutory authority. It was created in 2005 by a law made by Indian Parliament. So you know, Right to Education Act 2009. It also speaks about the duties of the NCPCR, National Commission for Protection of Child Rights. And we have Information Technology Act 2000. We have the sexual offences affecting the children. So that is one law, 2010. We have the Prevention of Child Marriage Act 2006. So all these laws, they come under, if a child is involved in any cyber crime or in any child pornography, they all come under the jurisdiction of the NCPCR. So I said Prevention of Child Marriage Act 2006, and then this one, Protection of Children from Sexual Offences Act 2010, Information Technology Act 2000, all these are the existing legislations to deal with offences against the children. Even Indian Penal Code, Bharatiya Nyaya Samhita, BNS, also contains many provisions affecting the crimes against the children. So you need to spell out these existing provisions and how to strengthen NCPCR to address the problems being faced by children, especially digital era, which means increasingly in the digital era, there is this problem of abuse of children through child pornography or even like cyber crimes. All of this, to handle them in a better way, you need to empower NCPCR. That's the question. Energy security constitutes the dominant kingpin of India's foreign policy. This is again a current affairs question and is linked with India's overarching influence in Middle Eastern countries. How do you integrate energy security with India's foreign policy trajectories in the coming years? To give an example, initially, we were depending a lot on Iran for energy supplies. United States of America said that they are developing atomic weapons, don't purchase oil from them. So we stopped purchasing oil from Iran. We started importing from Russia. Now Trump says, don't buy from Russia. Then what about the energy security of India? So interests of India are more important than the interests of United States of America. So we said we cannot avoid buying from Russia. So that's the issue. Energy security constitutes, India is a developing country and Modi has given a slogan, India has to become a developed nation by 2047. Vikasit Bharat. What is the size of Indian economy today? $4 trillion. We want to become a $30 trillion economy by 2047. For this to happen, there must be economic growth. For economic growth to happen, we need energy supply. We need to secure energy supplies. So, securing energy security is one of the important interests of Indian foreign policy. That's the question. Energy security constitutes the dominant kingpin of India's foreign policy and is linked with India's overarching influence in Middle Eastern countries. How would you integrate energy security with India's foreign policy trajectories in the coming years? Earlier, our policy is non-alignment. So earlier, we had this Cold War, 1950 to 1990. So two superpowers, USA, USSR. We said we will not join with any superpower. We will try to protect our interests. But now there is increasingly shift towards multi-alignment. We will associate, we will join with any country which takes our interests forward. That is called multi-alignment. We are with China, Brazil, developing countries in BRICS. We are with the developed countries in G20. Multi-alignment, that's the story that we need to discuss here. See, the reform process in the United Nations remains unresolved because of the delicate imbalance of East and West and the entanglement of USA versus Russo-Chinese alliance. Examine and critically evaluate the East-West policy confrontations in this regard. See, in the changed world, so UNO was created some 75 years back. Today, India is the country with the largest population. India is the world's largest democracy. Don't you think that a country like India with highest population and being the world's largest economy, largest democracy, it deserves a seat in the permanent security, in the Security Council. In the UN Security Council, it deserves a seat because UN Security Council composition must reflect the changed demography of today. It was constituted some 75 years back. In the last several years, many economies have emerged. Brazil, Germany, Japan, India, they are aspiring for a permanent membership in the UN Security Council. Any international organization must reflect the changed demography of today to make it more relevant. So the countries like Germany, Brazil, Japan, India, Russia already has a permanent seat in the UN Security Council. So because Soviet Union was replaced by Russia. So there are these are called G4 countries. They are demanding a permanent seat in the UN Security Council, but the West is not allowing that. So that's the dilemma. So the USA on one hand, Russia, China on the other hand, they are competing with each other. Though Russia is interested in our permanent membership in the UN Security Council, China is not interested. But initially we supported China to get a permanent seat in the UN Security Council. India supported China to get a permanent seat in the Security Council. Earlier, China was a communist state. It was not given any membership in the UN Security Council. Taiwan was given, in fact. Later on, China was given a permanent seat in the UN Security Council, and India supported that. But now China is not supporting. So that's the issue in this question. Question number 20, the reform of UN. The United Nations Security Council and also UN, it doesn't reflect the changed world. It has to be reformed. But there are disagreements between the countries in the East and the West. This we have done, NCPSR we have done. See, what are environmental pressure groups? Discuss their role in raising awareness, influencing policies, and advocating for environmental protection in India. So there are many environmental groups. If you remember, there was one committee which was appointed by the India government to review environmental laws. Earlier we had TSR Subramaniam. So TSR Subramaniam was former cabinet secretary. Under the chairmanship of TSR Subramaniam, a committee was appointed to review all the environmental laws in this country. like the Wildlife Protection Act 1972, Environmental Protection Act 1986, Indian Forest Act 1927, Forest Conservation Act 1980, another 10 minutes. So all these laws were reviewed by TSR Subramanian Committee. So there is a growing conflict between development on one hand, promoting development and conserving environment. So government wants more development, more economic growth to create jobs. But the environmental groups, they don't want undermining the natural environment. So this tussle is going on. You know, this under the Environmental Protection Act 1986, we have environmental impact assessment notification. All these laws are being diluted to facilitate development. And to counter this, there are many environmental groups which are working on protecting the environment, protecting and preserving the environment. So we have done collegium, constitutional morality, globalization. Accepting this question, we have done all the questions. India-Africa digital partnership is achieving mutual respect, co-development and long-term institutional partnerships. This is one question. And the first question also I have not done. Discuss the corrupt practices for the purpose of the representation of the People's Act 1951. I don't think that this is an easy question because section 123 of the Representation of People's Act defines corrupt practices. So this is a factual information, remembering it bit difficult. So the first 5 questions in this paper not very easy. Okay. So this one, discuss the corrupt practices for the purpose of the Representation of People's Act 1951. Analyze whether the increase in the assets of the legislators disproportionate to their known sources of income would constitute undue influence and consequently a corrupt practice. Remember, we don't have one legislation dealing with the corruption of legislators. We have also Corruption Act, Prevention of Corruption Act 1988. That is one legislation, and this is one legislation. Representation of People's Act 1950. What is the difference between these two laws? Representation of People's Act 1951 deals with the corruption associated with elections. When you contest for an office of parliament or legislature, or when you are exercising your vote as an elector, when you are indulging in corrupt practices, that is defined by Representation of People's Act 1951. And Prevention of Corruption Act 1982 also deals with the corruption of the politicians. So there are 2 laws in this country which deal with corrupt. And in fact, he says assets disproportionate to the known sources of income, it doesn't come under the Representation of People's Act 1951. It comes under Prevention of Corruption Act 1988. So you need to answer referring to these 2 legislations. So that's it about GS paper 2. We have done all the 19 questions excepting one question. India. So thank you.